and immediately quell, Erin is going to pop in and take over until such time as the dog situation has been handled. Fortunately, yesterday, no such dog incidents. Anyway, so today, I'm glad you're back. Today we're going to talk about some of my favorite things. Durable powers of attorney for finance and durable powers of attorney for healthcare, which are also known as patient advocate designations. And those two documents often go by their acronym, DPOA or PAD. And sometimes when I'm speaking, an acronym will come out. So I just want you to be familiar with them from the get-go. The next topics, yeah, well, they don't need an acronym. These are guardianships and conservatorships. These are probate court proceedings. And this presentation is really going to talk about when documents are preferable, when guardianships are necessary, and how do you know? So with that, Erin, I love telling Erin what to do. Sorry. Anyway, again, very briefly, Neighborhood Legal Services, our parent company, they are a nonprofit. They have been around since 1966. And because of them and their interest in elder law and advocacy was born in 1996. And what we do is we provide free legal services to Wayne County residents 60 and over. We also serve caregivers of older adults because there are more and more of them and they need some help. One of the things that we are known for is our First Tuesdays presentation, which used to be an in-person performance. It was great, loved it. Now it is a Zoom presentation, but it is also very good, and we provide many people in the community with information, most of which we're going to cover today, maybe a little bit more in depth today, because that's how important durable powers of attorney are, and how important it is to know to get them, and that by getting them, you will not, hopefully, ever have to be involved in a guardianship or a conservatorship. We are funded by, the Older Americans Act by way of the 3 area agencies, one being DAAA, the Detroit Area Agency on Aging, the Senior Alliance, and the Area Agency on Aging. I always get that wrong, 1B, and that's AAA 1B. So without further ado, well, I do want to point out that we are being funded in large part today by Erin, who's our large funder, please?
Our sponsor today, the Michigan Health Endowment Fund.
I'm sorry, should have been on this slide. Bad, Tracy. Okay, so we thank them very much for the opportunity to be able to provide this information to you. So carrying on, let's get right down to it. These are the documents and the proceedings that we're going to discuss today. And as I did yesterday, if you were fortunate enough, unfortunate enough to have been in the presentation yesterday, you know that what I tend to do is let people know what I want them to get and to take away from any presentation that I do. And in today's presentation, it's really 3 slides. It would be this slide that identifies the 2 durable powers of attorney for finance and healthcare, and also the description of what those documents are. And I'm just going to read that really quickly, that durable powers of attorney for finance and healthcare. These are documents where an individual who has capacity, which we'll get back to, they have capacity to execute legal documents and convey legal authority to the person of their choice to manage their finances and healthcare. That is critical. Now I'm going to just quickly read the definitions of guardianship and conservatorship. And again, these are court proceedings, probate court proceedings, where a judge conveys the legal authority to an individual to act on behalf of an incapacitated individual. And in doing so, that guardian has authority for healthcare, education, and residential placement. Conservatorship, similar, very similar, with 2 exceptions. The probate court, again, has the authority. The judge will convey legal authority to an individual to act on behalf of another individual, but this individual is not incapacitated like in a guardianship. In a conservatorship, an individual is in need of protection, someone who needs assistance. They do not have to have a conservatorship appointed for them. They do not have to be deemed incapacitated. And that is an important point. But all of the documents on this page, all of the proceedings on this page, they exist so that legal authority can be given from one person to another. And let's move on to the next slide. Next slide, Erin. Okay, so again, what I want you to take away was the slide that we just looked at and the next 2. And now is story time. The best way to really understand or get an idea of why it's important to know the difference between these documents and what is perhaps better, a better way to go, is to actually have a comparison of a fact pattern. So here's this story, and you know, I am the star of this story, and I'm an older adult, okay, like most of my clients, maybe a little younger, but I'm up there. I'm in the range. I fit the criteria, and I've just had an accident, and I'm unconscious. I need surgery in order to get the use of an arm back, a hand. So in this story, who has the legal authority to make medical decisions on my behalf since I'm unconscious? And the key here on this version is that at this point, I do not have legal documents. I don't have a durable power of attorney for finance or for healthcare. So the story is that my 3 siblings and my significant other show up at the hospital. And only my significant other agrees with the doctor when he's gotten them in a group to discuss what my status is. Only my significant other agrees that I need surgery to save the use of my arm. There's also a concern, and I'll just get it out of the way, that I may have some TBI issues and it might have lasting effects. So this may be something that is ongoing. The hospital is going to insist, when they see in front of them 3 siblings and another person arguing over what to tell a physician, the hospital is going to step in and they're going to say, well, you know, do you have any legal documents? No, she had none. So the hospital only wants to get information from one source. They want to know who they're supposed to listen to. They don't want to have to figure out or have the liability of making a decision that in the long run may have been incorrect. So they're going to ask either my sisters or my significant other to file for an emergency guardianship proceeding, okay? And it's conceivable because I need to have the surgery in a relatively quick time frame. It could be that they would be able to get an emergency hearing, in which case the representative from the court would come out to see me, perhaps meet them, and determine, you know, what the status is. And then in an abbreviated manner, the court would determine or appoint a temporary guardian in this case, okay? And let me give you a few more of the facts. My siblings, by the rules of the estate incapacitated individuals and protection code, EPIC, I'm sorry, I'm tripping over EPIC. My siblings have the authority, because they are family, at a certain level of family, that they have authority, but I haven't had contact with them in 20 years. We don't know each other's, you know, comings and goings, our likes and dislikes. You know, we're not together. We're not open about that. But my significant other, unfortunately, I've only known him for 6 months and we really like each other, but it's only been 6 months. And I'm just giving you that information because given these facts, what will happen, especially since the parties do not agree on the treatment, this will be a contested hearing. And again, they may give a temporary appointment so that someone can make that decision about the surgery. But because they can't agree, it's possible that that temporary guardian is going to be a neutral third party. Okay, so it would not be my sisters or a sister or my significant other. Okay, and based on the facts and the fact that it is going to be a contested matter. My experience in Oakland County, in Wayne County, in Washtenaw County is that the judge is definitely going to appoint a temporary neutral professional guardian, and more than likely a neutral professional guardian, the same one, to continue as my guardian. So that's one set of facts here. And you'll see that even though my siblings are family, they don't get to make a decision. They get priority when they're being considered for an appointment of a guardianship or a conservatorship, if the case may be. And unfortunately, my significant other, he's got no priority. He's at the bottom. So if there were, and I would imagine they would fight over me, there's going to be a hearing. There could be several hearings to determine who is the appropriate person. And since there is an issue of priority of petitioners, or who should be appointed, this is going to take a lot of time. There's going to be several hearings. I wouldn't doubt that attorneys would be brought in, because my significant other has the burden to prove that he, even though he has no preference, no priority under EPIC, he's going to have to prove that he would be the more effective, the more appropriate guardian. So, and again, based on this, my guess, and I really think I'd be right, is that it would be a neutral professional guardian all the way, and payment for that neutral professional guardian would come from my assets. And I am now a ward of the court, and my guardian is the only one who can make decisions for me regarding medical health care, if I was younger, education, and residential placement. All right, now we're going on, we're moving on. Next slide, please. So same situation. I don't have to explain the facts, but all the parties are there. And the only difference is that in 2012, I had gallbladder surgery and I was sure I was going to die. So I had legal plannings drafted, legal documents, planning documents drafted. And as the case would be, if you go to a hospital, the first thing they do, literally, hello, do you have a patient advocate designation? Do you have a medical healthcare power of attorney? And gee, guess what I did? And I gave it to them. Good. So that was a wonderful thing, because look at what transpires. All the parties are gathered around, the sisters and the significant other fighting in front of the nurse's station. Everyone's unhappy. And in walks my cousin Barbara. And she walks right in, walks up to the nurse's station, asked to speak to the doctor, says she is the advocate under my patient advocate designation or my medical health care power of attorney. And boom, suddenly I'm whisked off to surgery and my arm is being operated on. Notice the time period, nothing. No stop and wait, no, well, what about the arguing sisters? What about, the significant other? We don't care. Doctors, they want to look right, not even just doctors, the hospital. They want direct communication. And because I had a durable power of attorney on file. They knew, the hospital did, who to listen to, and that the information that they would get from that person would be in keeping with what my wishes were, how I would want to be cared for. So at this point, everything's pretty much over. The sisters are quieted down, kind of bummed out, they leave. And my patient advocate, Barbara, and I, we have some coffee together. Oh, not me, I'm in surgery, sorry. But my significant other. So that's how easy this incident can be. So I just want you to think about the differences and how I benefit, because A, I'm not waiting for surgery. I am not losing time. My nerves, I'm not losing, by not having surgery as quickly as possible. I'm gonna have a better outcome. And there really wasn't any fighting amongst anyone after it was clear that a person who was identified as my choice was there to take over, to take control. So there's a lot I could say about this slide, but I'm going to move forward. And we will maybe, talk about it as we go through. But again, the reasons why there is a preference, and there really is, for individuals who meet the capacity requirement and can execute legal documents. And in this case, it's not just legal documents, because certain documents have different standards, okay, different requirements. And durable powers of attorney are the lowest, okay? And we're gonna talk about in a bit what the criteria is for that. But the basic benefits are here on this slide for you. And I can sum it up. It's because you never know what's going to happen. We think we do, we put it off. And some people get hung up. They don't want to deal with their wills or trust. They don't want to think about money. They certainly don't want to think about death. But these documents, we're not talking about death. We're talking about life. We're talking about giving someone the authority to save your life, to make decisions that are in keeping with your wishes. So, if you are like me, and I hate to admit it, but I do have a little bit of a controllingness about me, I am gonna want to choose who's making my decisions. I'm also gonna want to be able to talk to that person and tell them, this is how I handle my finances. I'm conservative. This is my end goal. If you need to step in for me at any point, this is what my approach has been, and I would like you to continue. All right? And the same thing is true with my advocate, my patient advocate. I'm going to tell them, I feel very strongly about end of life. I want this. I do not want that. I may want to donate organs. I may want to have specific treatments that I don't want. I can list that. I can tell my patient advocate to, when and if the needs arise, how I would act so that they will act appropriately for me. The other reason that you want a durable power of attorney is because there's some protection. Agents under a power of attorney, even though they're not responsible, for instance, if I go out and oops, get into a little credit card trouble, they're not responsible for my debt. They may be responsible for hiring an attorney to, to mitigate the debt, but they're not responsible. And the other thing is that agents under powers of attorney answer to a fiduciary standard, right? There are things that your agent must do, must act on your behalf, must have your best interest at heart. And again, if reasonably possible, follow that, in my case, if I'm the principal, my instructions, what I want. That's what a fiduciary does. And that's different. Forgive me, I know I am hopping off point here, but it's important, especially to you who deal with this all the time. A lot of people feel that, and mainly it's seniors, feel that, oh, it doesn't matter. I put my son on my account. We have a joint account. So he has access whenever he needs it. Well, why is that a bad idea? Because your assets are now subject to his debtors. Sometimes we don't tell our parents that we like shoes and we have a lot of them, but we don't pay for them very often. We just charge them. So if I had a large debt, as you know, as bankers, a joint account is collectible. That's both of our money, whether it's my parent and I'm the child on it. If someone owns a debt and her name's on the account, it's gone, okay? Powers of attorney, they have a lot of power, but they don't have the power to act in bad faith. And if they do, they can be removed. And this is different than a joint account holder, because legally, if Erin and I were on an account, Erin can do whatever she wants. And forget my shoe situation. I don't know what Erin's got going on. And
Shoes.
What was that?
I said shoes.
Shoes. See, it seems to be consistent. See, consistency is a good thing. Anyway, let me get back. I'm doing what I promised I would not. What I'm saying is, here's a list of reasons why we want agents under power of attorney, okay? We don't want to have to go to court to have someone make decisions for us. We want to be in control. And that's what powers of attorney do. That is their purpose. And there's just that one caveat. And we'll get to that in a moment. Erin, next slide. So I am not knocking guardianships and conservatorships. They're very important. And the courts are good at them. And the judges, are there to protect you. And that's what they do. And sometimes that doesn't work out the way we would have wanted it to. But by this point, if we're in a court proceeding, they're trying to determine if we have capacity at all and whether, you know, we may not even have the ability to weigh in and say, Judge, I don't like this. Now, there is, and I'll get to this later, now I'll say it right now. There's always the person who is at the heart of either a guardianship or a conservatorship matter, if there is a petition filed. And it's never by them, right? It's either someone who cares about them or someone who wants money from them. The interested party who's at the heart of the matter. So in this case, me, if I needed a guardianship, I always have the right, even if I'm incapacitated, to say, I object. I object. And the proceeding that we'll talk about later will stop, and I will be appointed attorney. I will be appointed an attorney because I'm already an attorney. I'll be appointed. Aaron likes that. Anyway, so I will get representation, no matter if I appear to be incapacitated or not, because we have the rights as citizens, no matter how old we are, no matter what our circumstances are, to disagree and to have our day in court. So now, I told you that I'm not dissing guardianships and conservatorships. I'm not. I just want you to know that there's safety nets. And when there are situations, when there is an older adult who's been neglected and is injured and they fall in their apartment because of self-neglect, and they go to the hospital and the hospital doesn't know who to contact. Who do we contact? There's no one. The hospital is going to petition the court, and the court is going to appoint, determine whether this person requires an attorney, and if so, they will appoint one, and there will be a hearing whereby this person will, if they need it, if they meet the criteria, and if the judge feels that that this person, by reason of mental illness, drugs, age, if that is the case, they will make sure that this person has someone to look out for both their medical health concerns, their placement concerns, as well as, if there are assets, their financial concerns. That's why guardianships and conservatorships exist. They're not bad. They are good. Now, we've already identified, at least I have, I just don't know that I pointed out to you or not, but the one thing that determines whether an individual can execute a legal document is capacity to execute a legal document. And this is difficult. This is not easy, unless it is easy, unless I show up at Erin's office and I say, Erin, I want to execute some documents. And we have a conversation, and she gathers that I understand that this is what I want. I want to give away something, my authority. I want to give it to another person in case I'm not able to manage my affairs, give informed consent. So in a case like that, capacity's pretty easy. I've got capacity. It's a good thing you don't know everything about me. But anyway, next slide. What it comes down to is that the principal, and I'm referring to the principal here, that is the person who is going to execute a document. The principal is the one who comes to a lawyer and says, I want to have this document, would you draft it for me? So when determining the capacity of the principal, you want to, and I'll just describe what I do. Attorneys will meet with that individual, and I would say without a doubt, most attorneys would want to meet with me individually, with no family around. And they're going to talk to me to see, do they understand that that's what I'm doing? Okay, do I want to not have this authority anymore because I see a benefit by giving it to someone else? And is that what the principle or what I want? And the last word here is critical. Is my decision to do so voluntary? If there is a sense that it's not voluntary, I mean, I might have capacity, but I might be unduly influenced by someone in my family to get a document and appoint them. When a legal document is drafted, the attorney needs to look at, again, the totality of the circumstances and the person in front of them. And if it's an elder person especially, you know, why do you want this document? If you understand that you're giving things away, and if you understand that there's a benefit in doing so, great. But it's key. Is it voluntary? So that's something that you want to know. And attorneys at that point, if it wasn't voluntary, if there was a sense of, well, my son said, if I don't do this, I have to do this. In order for my son to sell the house, he needs this. Those are not reasons for appointing anyone as an agent under a power of attorney, okay? And it can shed a light on, do they really have the capacity to make this decision if they are making it for a reason based on fear? So I'm not sure in this circumstance that if I was the attorney, that I would draft the document. But I want to get back to capacity because there's another little thing about capacity, and that is, Erin, next slide, please, that capacity can fluctuate. I know you know people like many of my clients who, and for that matter, my mother, who are either experiencing just the aging process where their memories are shot. Their short-term memories are shot. If I asked my mom about, you know, what we had for lunch, and we had lunch 10 minutes ago, she wouldn't know. She wouldn't know. She'd have to think about it. It would be hard. And then she'd say, Tracy, what do we have? But my mom knew what she wanted. She knew she could make decisions for herself and go through the process necessary to determine capacity, in the sense that she, even if she forgot, even if she forgot what we had been talking about, say I had been asking her about her power of attorney, which was drafted years ago, and she's forgotten the terms. And if I explain to her what the document says, what it means, how it's used, and you know, does she think that's a good thing to have someone have the ability to assist her if she does not have the ability to give consent or manage her her financial affairs? And she says yes. And I ask her that 20 minutes later. What's a power of attorney? And I don't know. And she gets kind of hazy sometimes, and she doesn't give direct answers. But if I sit her down again, same day, maybe the next day, I talk about the same things again. And I'm very careful about it. I go through it, I describe the document. I ask her if this is something she is interested in, and does she understand that she's giving away something, a right of hers, to another person? And if she did, who would that person be? And perhaps why? And if she says, she gives me the same information again, I'm going to be able to determine, and maybe not just twice, maybe a couple more times, if you have an individual who is suffering from, you know, more than a bad memory, if it is dementia. But I'm going to be able to say that I found capacity. Now, I'm discussing something right now that's actually on the next screen, but I want to talk about, now that I've explained that, what's in front of you on this screen. And that is that capacity does fluctuate. And there are things that cause capacity to fluctuate. And especially when you're dealing with people who are my age and above, who might take, I don't know, a handful of pills every night, prescribed, of course. But that can have an effect. It can have an effect on me, and we already know, I hope you've decided that I have capacity, but it can cause me to get sleepy. It can cause me to get forgetful, some of the medications that I take. If I am, and this has happened more often than I care to admit, I've been working remotely in the grotto for months, but when I go into the office, I am so discombobulated because it's a different place. Like my computer isn't in the right place, and where's the garbage can? I can never find the garbage can. So imagine I'm maybe not older, but more, I have a more advanced, I'm just saying that I have an advanced something. Say that I do have dementia. Little things like that are going to be enormous, okay? And especially those of us who have family members who are in nursing facilities or independent living facilities, if they're ever hospitalized, you take them to the hospital. And if you haven't heard the term sundowning yet, take a loved one who lives in a very routine, rigid schedule and move them into a hospital where there's noises, there's sounds, there's everything. Do not be surprised when the person who's in the hospital, your loved one, starts acting out, starts forgetting things, starts acting erratically, can't tell you, do I have a power of attorney? I don't know if I have a power of attorney. Tracy, do I have a power of attorney? What happens is we have to recognize that these issues, and in case of the first column, illness, medication, but also time of day, right? Sundowning is, it can start at 4 o'clock. Not now. Sundowning now. Sundowners love daylight savings time because sundowning will start later. I'm kind of joking about that. I don't actually know. I didn't test that out, but wouldn't it be great if it did? But anyway, the time of day is going to affect somebody's capacity. So when someone is determining another person's capacity, and might I add at this point that should be an attorney, it should be if there is significant concern whether a person has capacity, I would contact a geriatric neuropsychologist or a gerontologist and just have a review. Now, caveat, asterisk, physicians are more likely to determine competency. Competency, capacity. Capacity is a legal term. We use the legal definition. And in Michigan, even though there isn't in the statute, there isn't a definition of what capacity is. We take from state law that it is the ability, like I explained before, is there an understanding of what is being given up, that it's being given away, and is it a benefit that the individual will benefit from it? Then you have capacity. Now, sometimes you will find that people don't. I've met with people on many occasions, and I've recommended what I've done what I've recommended, met with them several times, had the same platform, the same information to see if I would get consistency, and I don't. And then I know that's not there. And I think I said it before, but for this type of legal document, for a power of attorney, it is a lower bar. It is not, you do not need to know the amount of your assets. You're not writing a will, you're not devising. What you're doing is giving someone the authority to do something you once could. So, quickly, I'm sure while I was babbling, you were looking at beyond time of day, medications. Oh, this one's big, especially with this group. I'm getting there, especially with this group. Grieving, loneliness, other events that alter the routine. Those can all have a significant effect and temporarily impact the ability to find capacity. But they're limited. You've seen education, language, those are more obvious. You know, if someone comes to you and they're speaking Chinese, do they understand you when you're explaining a document? I don't know. And our languages may be different. They may not, even if they do understand, it might be better in those situations to have a native speaker. Okay, now, Erin, now move me to the next slide. I know. So I've kind of touched on this screen, even though I love it. It's one of the prettier screens. I did talk about most of this while I was talking about capacity. So what you're looking for when you have someone who maybe has compromised capacity, who is being affected by medications or residential placement or, excuse me, facility placement, what you're looking for and what is viable are lucid moments. A document that is executed by an attorney, properly executed by an attorney, is valid, even if the person who signed the document has no memory of it, no context of it the next day, or even 3 hours later. But that attorney or whoever, you know, executed that document should have, as we've discussed, jumped over to when there's questionable capacity and meet with someone separately on multiple occasions and see if there is consistency. People can think, they can think. They may not remember, but they can think. So all we have to do sometimes is put it in front of them as if for the first time, ask them questions, ask them about themselves, ask them whether there's someone they trust. Would they want to give away their authority? And do they trust this person? If you get a consistent response, I believe as an attorney that I can execute a document because they do have the requisite capacity at the time that I am discussing the document and they sign the document. And this is very important because as you've seen so far, it is much better to have a legal document, a power of attorney, than to have to go to court. Next slide. So now we're just going to walk through really quickly some of the details. I've hit on most of the critical information. There's a few terms here that I want to point out. I think you have, if you weren't already familiar, and because you're financial professionals, I know you know these documents. I know you know. I hope you have them. I want you to have them. And I want you to know what to look for when your customers have them or your clients have them. So the person signing the document is the principal. The person who is given the authority to act under the document is the agent. And there are two different kinds of power of attorney. Now, I don't like to go heavily into the two different kinds of power of attorney because it may, at least for the target audience that I work with elders, it really behooves them to have what's known as an immediately effective, durable power of attorney. And what that means is at the time that the principal signs that document, that agent has the authority to act on behalf of the principal. That quick. All right. And when is that a good thing? Well, if you're like me and you had a mother who's 92 and, you know, she was not incapacitated. She, as I said, she had some memory issues, but she also had significant hearing issues and sight, vision, couldn't see a thing. So it was really beneficial since she couldn't talk to people on the phone to make financial changes. She, you know, wasn't able to use the computer to do things. It was very helpful that for the last 3 years before she died, that I was able, as her agent under power of attorney, to manage her affairs. And I was able to do that. She was not incapacitated. Now, why do I say that? Because the other document, the other kind of durable power of attorney for finance is a springing durable power of attorney. And the document is not as fun as it sounds, okay? What a springing power of attorney is, and when they are appropriately used, is when you're younger, okay? You have young children. You don't have like those of us who have, you know, reached 60. You haven't amassed a series of medical conditions, so you're pretty good. Of course, you never know, which is why you have your documents, but you're pretty good. So what you can do is you can create your documents so that it does not become effective until 2 physicians, till you're incapacitated, basically, and 2 physicians or 1 physician and a psychologist deem that you do not have competency, you're incapacitated, that you cannot manage your affairs. And again, remember, doctors have different standards here. We're not going to get lost in that, but going back. So that would be an instance where a springing durable power of attorney was appropriate, right? Because highly unlikely that someone would have to act, but if there was an emergency, you were at the hospital, 2 doctors would say, yeah, this person does not have the ability to give us informed consent. Therefore, that automatically activates the document. Now, I was just talking about a PAD, sorry about that. I sort of merged my medical with my financial. And it was a bad example to give you, hopefully not. Hopefully, let me reiterate that. Because one thing that I want to tell you is that the ability to create a springing document is only possible for a financial document. Okay? When we get to it, you will see that medical healthcare power of attorneys, or PADs, only become effective. The agent can only act when the principal, me, does not have the ability to give informed consent. Okay, so that's the difference here. With an immediately effective, durable power of attorney, where it's a benefit to the principal, like me and my mom. It was helpful for her, even though she was not incapacitated. She was fine. But I was able to act as her agent and manage her finances. I was able to act to take care of selling her home and moving her where she needed to go. These are all things that, you know, she could have done, but it would have been hard, and it was easier for me to do. The other thing about immediately effective, durable power of attorney is, and this is where I might be repeating myself just a touch, I got to look at the clock here. Okay, just a touch, is that springing durable powers of attorney, like I said, they have to be activated. Now, if it's an emergency, easy, doctors are there, it's activated. But if you have a medical emergency, but you need your durable power of attorney activated, you would have to show that documentation from the two physicians or the one physician and a psychologist. You would have to show that to be able to act. So at the hospital under a PAD, you may be good to go. But before you, unless you get those doctors to sign something when you're right there, you need to take that to the bank so that the bank knows that this is an effective document. So sometimes that the amount of time that it takes to get doctors to say, yes, you don't have capacity, so that you can also act as an agent under a durable power of attorney, that there can be a holdup there. So what we say is, if you trust this person to be your agent, what's really going to change? This is our argument to older people. What's really going to change between now and then? And why would you want a springing document if you trust the person now? And wouldn't it be more efficient to have that person? They don't have to act for you, but they're there, right? They can act for you. So isn't it better to know that if there's an emergency, if there's a situation, your agent would have the appropriate authority to act, even if you were unable to get those doctor's letters quickly. Okay, and quickly is the key here. So durable power of attorney finance. I have hit on these over and over and over. The one thing I want to clarify is the agent steps into the shoes, which is why we have those lovely shoes. And the principal has to understand that what that means is that the agent has all the authority that the principal had, all of it. So there is this big leap of faith. There, you must trust your appointed agent. And again, I think I mentioned that agents do have to act under a fiduciary standard. And did I go over the benefits of a durable power of attorney over a joint account? I think I did. Oh, it was the shoes. Yes, remember the shoes. And now it was worth it just to get that beautiful photo, because yes, the principal must trust someone, trust the person that they appoint as agent, and someone who will act in the principal's best interest. And one of the things we see a lot of, and we have to educate our clients, is, well, I have 3 children. Can't they all be, I want them to be co's. Can they be co's? And I'd say, if they don't agree and they all have to appear at the bank to sign something, is that going to be problematic? Yes. It's the same reason why PADs, patient advocates, you cannot have co-patient advocates, okay? There has to be one voice, one person that and a professional can look to for direction. And even though, as it stands now, you can have DPOAs, agents, but it's not efficient. It's a mess. I'm just reporting to you as someone who has seen it, and it's important that our clients recognize you're not appointing someone because they're the oldest. You're not appointing someone because you liked them better. You're appointing the agent to the task that they best suit for you. This is a very self-centric document. It's about you, what's best for you. Stop thinking about the 3 of them. They'll get over it. Carry on. So now, and I wanted to go touch on this quickly, because it seems to me that this is something that you as financial professionals have to deal with, have to look at. And especially when we're seeing undue influence by family members or others, it's possible that someone's going to print off a downloadable fill in the blank power of attorney. And they're going to put it in front of someone and they're going to say, sign that. And then they're going to, get 2 witnesses. Because they think this is how a legal document should be signed. Well, in Michigan, DPOAs have to be notarized and or signed by 2 witnesses. And because other states require both, most attorneys in Michigan are going to notarize it in the presence of 2 witnesses and have them sign. So even though if someone gave you a document that was just witnessed by 2 witnesses, that is effective. But if you're the person who's having your documents created, you want it notarized and signed by 2 witnesses, okay? And just a point here, the agent is not a witness, cannot sign. They're a party, they're a player. And hopefully it isn't the last, but it's gonna be. Agents must now sign, since 2012, agents must sign an acknowledgement of responsibilities for the durable power of attorney to be effective, okay? If banks are not receiving that acknowledgement, then that DPOA by itself on its face is invalid, right? They must be together. You must have them. Next. responsibilities. I think we went over this, except for maybe what agents can't do. So when you're reviewing a document, again, this would be a sign of perhaps some undue influence. You may not gift under a durable power of attorney unless it is specified in the durable power of attorney, and specifically specified. For instance, if they need to spend down for Medicaid planning, if that is in the document, then yes, the bank is going to say, aren't you? You're going to say, okay, yeah, no, go ahead. We're going to do that. But that gift to yourself of the, the Ferrari, no. Okay. And I keep saying this, but the other thing you can't do as an agent is open a joint bank account with the principal, which defeats the point of almost everything. And your bankers, you know that, carry on. Moving on. And what should people do with these POAs? They should take an original to the bank, and you should take the original to the bank and have them scan it for their files immediately, and then take it back. You want to have that original, because for everyone else who's going to need to see a durable power of attorney, with an exception here and there of out of state financial needs, the majority of the time, a copy works as an original. But you definitely don't want the bank, hear that, bankers? You do not want, you don't want a copy. You want to see that seal. You want to see those witnesses' signatures. Okay, and durable, okay. Durable power of attorney, you know, all the flexibility and the ability to point who you want and trust. Everything I said about the financial power of attorney is the same story for your medical health care power of attorney, all right? Now, one thing I will point out is under a medical health care power of attorney, or a patient advocate designation, as it's also known, the term could be patient instead of principal, and it could be patient advocate or just advocate instead of agent. Terms of art, they kind of move around. Now, important, and I think I touched on this once before, unlike an immediately effective power of attorney for finance, the medical healthcare power of attorney or patient advocate designation can only act when the patient does not have the ability to give informed consent. Okay, so you can't act unless you have that that document with you when the person who you are agent for requires your services. Okay, and at that time, you're going to have two physicians or one physician activated. And remember, that could be easier if it's an emergency because doctors are there. But that
Tracy,
may not be.
do you mind if we kind of skip ahead so we can do a little bit of guardianship and get some questions?
Yes.
Okay. So we've talked about durable power of attorney for healthcare.
I think everyone can tell that I have a preference.
Yes.
If you have questions, you can always ask. All right, so guardianship. All right, stay on this screen. I have been dealing with guardians and guardianships and conservatorships for years. I've never memorized this, so I'm going to read it word for word, because this is the criteria that an individual must meet to have a guardian appointed for them. Impaired by reason of mental illness, mental deficiency, physical illness or disability, chronic use of drugs, chronic intoxication, or other cause, not including minority, to the extent of, and then we get to the meat, lacking sufficient understanding or capacity to make or communicate an informed decision. Okay, so I've kind of been using those words, but not exactly. I haven't given you the by reason of, but now you have it. So that's a pretty wide berth. And oh, I'm just looking at the slide here, and I think it goes without saying that once a guardian is appointed, they are responsible for the continuing care and supervision of that person. Carry on. Next. There we go. So I also think that you may have gleaned that there's a difference between a guardianship and a conservatorship, and I'm going to speak a little faster. Guardians are about medical health care. They're about residential placing. Should mom live in the home, in her house, or should, who has the authority to move her to a nursing facility? The guardian has that responsibility. What the conservator has is the responsibility for making sure that if there are assets, that they do not become wasted assets. It isn't necessarily to appoint someone to grow the assets. It is the appointment to make sure that money is not lost, value does not go down, and that and the only thing I want to add, I'm sorry, I was reading Erin's note. Stop that. The thing that is important about a guardianship and a conservator is the amount of assets. And this is really important with my clients. And I know you deal with a lot of my clients, my older clients, who live on Social Security. All right. What happens when they don't have living documents? Oops, mom doesn't have the ability to make decisions. Oh, they've got to go to court, and mom has less than $2,000 in her bank account every month, and that's what she lives on. If she's incapacitated, does she need anything more than a guardianship? And the only reason I say that is because there is no real concern. Well, I'm pressed for time, so I'm gonna leave that argument, and I'm gonna go to what I recommend, what the court will recommend is what may have to happen if you are not already this individual's representative payee through Social Security. If you are, you're good to go, because you have the authority to, be on and access that rep payee account. All right. And rep payees have to account to Social Security, every year. So there's accountability. Conservatorships are different. Conservatorships are where monies can be, significant funds could be either exploited or taken advantage of or lost by not taking, watching what's happening to it, like a house that you have that you do not sell quickly, and the maintenance isn't done, and the asset is, it's called a wasting asset. It's not being taken care of, and it's losing value. So when you have assets like that, you will need to file, if you have a family member who requires it, or a client who requires it, there will need to be a conservatorship. There may not need to be a guardianship if the concern of your client is that they are just, you know, they really need some help. They're with it. They're not incapacitated. We don't want to strip them of their rights, which is what happens to an incapacitated individual. So maybe what they need is the conservatorship. On the other hand, my clients, just Social Security, $800 a month, $1,200 a month. What is going to be beneficial for them is to become the rep payee. And unfortunately, if they are not already a rep payee, Social Security will not look at documents or anything. They will demand a guardianship. Okay, so we've talked about this. You understand the differences. Can we carry on?
We can. We do have some questions about the power of attorneys for finances. And I don't know if you want to touch on those or just see if people want to email.
Stephanie, can we stay on longer and answer questions?
I don't know that she heard.
Okay. And there's no way for the crowd, you know, can the crowd say answer now?
Why don't we just, what the rest of it is basically going over the process of guardianship and how you have to, everything's in the court and public and all that stuff.
Correct. But so, I want, there's one last point, and that is that with FEPA, with the possibility that you're going to be, you know, identifying people who are being financially abused, you know, it's likely that guardianships will, you'll be dealing with the possibility of more guardianships than you've had before. And again, remember, even though what I said was guardianships, they're there to protect, they also have the harm that, you know, it strips the rights away from the individual. And that is a very difficult thing, since we were also talking about elder abuse. You know, you have to be sensitive. You have to look to the totality of the situation. And now let's answer some questions.
Okay, we can stay on a little bit longer to answer questions, but I think it would be good because we're going to, we do prefer the power of attorneys over guardianships. I think that should be said. So
I don't know if I made that point enough.
Yeah, I think maybe you did. So the first question is they get where a lot where they have the power of attorneys where the agent wants to add themselves as beneficiaries to the account, and generally they say no, but sometimes the gift wording seems to allow for it.
Okay.
What should be the stance on this?
Okay, so allow them. Okay, so when you're an agent under a power of attorney, what should happen, oh no, I have all those bankers out there who are gonna like chase me down, is that an account, and I don't know how all banks handle things, whether you close out the account and you open a new one, but it is similar to a rep payee account in that it is, the authority is in the name of the agent, for the benefit of or under the durable power of attorney dated such and such. So it's not a case of adding someone to the account, right? As a joint, that is not what we want to do. But you do want to identify the agent has to have the authority, because the agent is now standing in the shoes of the account holder. So the agent can do whatever the principal could do. I don't know if I answered that question fully enough.
We did get a comment saying that we don't open accounts for the POA or change the account to add the POA. So generally, you're going to want to read the document. Every POA should say what the document does. Like and they can be tailored. So one document might not match another document. Different attorneys draft different things. And so each individual client is going to have an individual document if you are tailoring them to your clients like we do, right? So it just, sometimes it will depend on what the actual document says to step into the principal's shoes.
Well, the majority of the documents will say, although, and that is something we didn't touch on, is that it is possible to draft a power of attorney that limits the powers. I mean, that's possible. It can be very broad, but you can also limit it if necessary. I don't want this person to have access to my securities or be able to deal with this, but my, bank accounts, I want you to have access to. But the agent under the power of attorney is able to write checks for the principal. I mean, generally, I've seen the agent's name on checks. That's how I have to look into this a little bit further. But I mean, other than just placing the document in the file, the agent under power of attorney should be able to issue checks and have checks in their name as so-and-so for the benefit of. But that's something that we can look into later.
Yes. So another question was about guardianship. So if a guardian has been appointed, does that generally allow them to act on behalf of the principal with their bank accounts? Or would a conservator also need to be appointed when there's a guardianship?
Okay, well, that's exactly what I was trying to squeeze into those last couple of minutes. So the case is, or the question is, what are the amount of the assets? And of course, the court will not give you that number. So what I've been doing is where there's a need for a guardian anyway, there's a definite need for a guardian. What you can do is add to the already plentiful paperwork that one must file for a guardianship. You can add a simple petition in order. It's a one-sheet form that says, based on the assets, is it would the court allow, special,
Special authority to deal with the money
yes,
too, because if you have
limited
really low
authority.
assets, you're
Correct,
not gonna really need a conservator
correct,
unless you have, that person has enough assets to actually need somebody to manage those.
exactly. But what might have to happen, and again, this is where, this is why the fact that bankers and lawyers are now talking together to make things work for senior citizens is really very helpful, because as an attorney, I've been giving information um, from an attorney's point of view. And I don't know what the bank is specifically doing, but in that case, that one specific case, the court will not need to open a conservatorship. And either I would, file with it an extension of authority to manage the Social Security account, the rep payee account, because that's really all that is necessary.
Yep. I think we have to go back to the power of attorney question, because I think we confused her. She says she was
You know what?
confused.
It's confusing. It's confusing. So let's go back. Can you, the question again is,
Was about the joint owner. No, I mean, it's not a good thing to have a joint owner on your account. I can say that for sure.
the purpose of having a agent under a power of attorney is so that agent has access and ability and authority to use that account. All right.
Right.
And so no matter how, I don't know what the procedure is at your financial institution, et cetera, and they do differ. But you're the one who has you're establishing the user ID and the password. You're the one who is managing that account. And when you are issuing payments, if you're writing a check, you're signing your name as an agent under power of attorney. Okay? So there should never be a time where an agent under a power of attorney opens a joint bank account. And if you look at the slides, that is one thing agents are not allowed to do. You cannot have a joint bank account between the agent and the principal.
Yes. All right. I hope we
We didn't.
clarified that.
And if you're confused, please call me. Please call me. Because I'm thrown off by the fact that you say that you don't need a new power of attorney account. So, we're equally confused, and we will learn from each other.
All right. So yes, we will make the presentation slides available for everybody so that they can get the rest of the presentation. Sorry we went so long.
It's a problem.
Well, thank you, Tracy and Aaron. I'm Nicole from the Education Department here at Michigan Bankers. Thank you so much for all your information today, and feel free to join us next week and register for the next series. So thank you, everybody.
Looking forward to it. And again, if there are questions that arise, let us know.
Thank you.
Thank you.